The hard part is showing the courage of conscience, the courage to do right as you see the right. I know you to be women and men of sound conscience. You are as decent, as honest, and as honestly self-critical as any group we could assemble. But do you have the courage of conscience? The courage to resist pressures, however great or subtle, to ignore the inconvenient commands of your conscience? When I look back at my early years as a Massachusetts prosecutor, I see with regret and some pain that I sometimes lacked the courage of conscience. I sometimes yielded to the contrary commands of my superiors, my pride, or my ambitions. I regret one case, my first homicide prosecution, most of all. A prosecutor's first homicide marks a coming of age. It's the prosecutor's transition from petty case punk to superior court somebody. Now, that first homicide isn't typically a chainsaw massacre. Typically, it's an unintentional homicide, often involving a car. The charge in my case was negligent motor vehicle homicide, and that charge meant exactly what it said. All I needed to prove was negligent driving that caused death. I didn't need to prove intent, or even recklessness, or even gross negligence. Simple negligence would do. But a man had died, and conviction carried serious costs for the defendant, the risk of imprisonment, and the certainty of a 10-year loss of driver's license. The facts were desperately sad. The victim had lived and died unnoticed. He had no job, no known family, no apparent friends. He had only a name and an apartment in an aging, Soviet-style, high-rise public housing project. He was sickly and gray. He walked with a limp and a cane, and he lived behind gray concrete walls. Even to his neighbors, he seemed a stranger. Maybe he ventured out only at night. At all events, he died at night, limping across the busy street that ran along the projects. He fell in the middle of the crosswalk. It seems no one saw him fall or knew why he fell, but he was conscious, and he knew he was about to die. That much we know because the defendant told police at the scene what happened. She had been driving at a normal speed, she said, with normal care, but never saw the man until an instant before she hit him. Even then, all she saw was his arm, waving his cane over his head, warning cars he was there. By the time she saw the man's cane, it was far too late to stop. All this she told the police after they arrived on the scene. Then, having answered their questions, she walked to the side of the road, doubled over, and vomited. Her teenage son, who had been riding next to her, looked on. The defendant didn't vomit because she was drunk. The police saw no sign of heavy drinking. They did not charge her with drunk driving. They did not question her account that she drank a single beer while spending the evening with friends. She vomited for a different reason, because her horror at having killed a man found no expression in words. Those were the facts when the case arrived on my desk. It was a homicide, my first. And I knew I could prove the charge. Cars must yield to pedestrians in crosswalks, whether walking or fallen down, whether in broad daylight or in pitch darkness. The defendant's own words convicted her. Yes, some jurors would resist this result. She suffered enough, they'd say, and there but for God's grace goes any of us. But the judge would instruct jurors they must decide the case on the facts and the law. The facts and the law compelled conviction. In the end, I felt sure, jurors would agree. Yet I did not want to prosecute her. I could prove the charge, but those first jurors were right. Any of us, if distracted for a moment, could have hit that man. A police expert who analyzed the scene confirmed that the defendant had been driving at a reasonable speed and the victim was already on the ground when she hit him. And the defendant had shown the courage to stop and wait for the police. Had she simply driven off, sworn her son to silence and gone home to bed, none would have been the wiser. Yes, she had been careless. She killed a man. But she intended no harm and showed great remorse. She posed no likely danger to anyone else. Yet the consequences of conviction could be severe. A 10-year loss of her license could trigger loss of her job and land her and her son on the street. With a homicide on her record, she might never find another job. So I approached the head of our homicide unit, my superior on the case, and explained why I thought we should not press for a conviction. Massachusetts law allowed a middle ground. The judge could defer sentence for a year and compel the defendant to attend a safe driving program and complete community service and not to drive except for work. At the end of the year, if she complied with the court's conditions, the judge could dismiss the charge. To me, this result seemed proportioned to the defendant's wrongdoing. But the homicide chief was a hard man to move. He was a prosecutor to the core, brother to one prosecutor, husband to another. He and his wife shared 2 state salaries and an old station wagon and scrimped to raise their kids. They had sacrificed a lot to serve the public, and I admired him for that. But he had a chilling lust to win and a contempt for the accused that I could not admire or share. The Supreme Court wrote in 1935, a prosecutor's first ethical duty is not to win the case, but to see that justice is done. He told me I should try that case and demand a conviction. Weeks later, as the case neared trial, I met with the homicide chief again. I was prepared for trial, but could not see the justice in pressing for a conviction. He never budged. He was either unmoved by my arguments or unwilling ever to show leniency, however well justified leniency might be. And so I had a decision to make. I could stand with my conscience and withdraw from the case, or I could cave to his command. There were good arguments for caving. The homicide chief had far more experience. Maybe he knew something I did not. Maybe he saw through the defendant's remorseful facade. Maybe, but I did not think so. I believed he simply knew no other course but winning. And yet I caved.